All right. And we are live.
Okay, great. Thank you very much, Sam. And we're going to call this meeting of the Data Privacy Task Force to order. I guess I'll start to see if Representative John Michael Parker has any words he'd like to say.
Thank you, Senator Maroney. Nice to see you. Thanks everyone for being here. Nothing in particular other than appreciate everyone's time and continued interest and engagement in the process. Grateful to have a big team here and looking forward to the conversation today. Thanks, James.
Thank you very much. And I think, unfortunately, because we had to change the time, I'm not sure if Representative Gilchrist is able to make it today. As Sam is Representative, I don't see her.
No, unfortunately, I believe as well she was unable to make it today.
Yeah, and I do apologize for having to switch the time, and I thank everyone for their flexibility. Unfortunately, a good friend of mine from growing up, so I'm going to the second grade, passed away unexpectedly, and so his service was last Wednesday. And so thank you for your flexibility in switching the time to this week. So with that being said, on the apology tour, I need to apologize that Sarah, I misspelled Sarah. It's Sarah Holland, not Sarah Hyland from Google. She'll be presenting at 12:30, and we may go a little bit out of order. Nicole, I believe you wanted to present it. Is that at 12 o'clock for the 5 rights? So
yes, that is correct. Yes, I'm here.
So present at 12 o'clock. And so we will then start. Is someone from Senator Gurnard's office on?
Yes. Hi, everyone. I'm Becky. I'm the policy director for Senator Gurnardis and the drafter of our child data privacy legislation.
Great. So are you all set then to present?
Yeah.
Okay, great. So if you take it away, Becky, please. Thank you.
Sure. Our bill, which I'd be happy to, in a moment, I can find it online and just drop the link for you guys in the chat. The number is S9563. I labeled it the New York Child Data Privacy and Protection Act, so it's called the CDPPA. What we are doing is creating certain obligations for online products, which is defined broadly as, could be an app, could be a website, could be any kind of digital product that is targeted towards child users. Child users we're very broad here. It's 18 and under, and targeted towards child users means that the online product knows or should know that its product is accessible to and used by children. We drew from a lot of other existing child data legislation when we were looking at this, most notably the California law that just passed for the I believe it's called the Age Appropriate Design Code or something similar. So a lot of these definitions, we weren't really reinventing the wheel. We were drawing from the existing legal language that's used to describe these entities. And we said that before a product that is targeted towards child users, an online product can go live, it has to complete what's called a data protection impact assessment, which is basically that entity doing sort of like an internal review of what the impact of that product is on the child, what kind of data they're collecting from the child, how they're processing it, who they're sharing it with, what kinds of controls the parent may have over all of that, et cetera. And we are housing enforcement within our Office of the Attorney General. There's a Bureau of Internet and Technology that sort of does similar things already. We create a ban on data collection, processing, and sale of child user data. So this is a really, really powerful part of the bill. You can't collect child's data and use it for targeted advertising unless that is A, either necessary to provide the product, or B, you can demonstrate that there's some kind of compelling interest that furthers the interest of the child. And that was drawn from the California law, which just passed as well. We require these apps and these websites to have what's called privacy by default, which means that automatically the setting is the highest possible privacy level for the child user that it can be. They can go in and manually change it, but the default is highest possible privacy. We're not too prescriptive, but we do give the Attorney General the discretion through regulatory action to ban things like autoplay, push notifications, prompts, in-app purchases, all of these tools which can be really predatory and sort of inappropriately extend the amount of time that a child may be using the app, fueling screen addiction and all these other kinds of things. This was a very important part of the bill with the lawyers that we're working on with this bill. We give access to the account of a deceased child user to the parent or guardian. There's a bunch of stories you could research where a child may have been a victim of a crime because of some kind of internet interaction, and the parent can't get access to that account. Law enforcement can't get access to investigate, and the parent can't get access to, for example, take down the account or alter it in some way, which they may want to do for their child after the child has passed. The terms of service would need to be agreed to by both the parent and the child. They need to be published in some kind of way that's accessible and easily understood by the child. We create a process whereby parents and children could notify the app of emergent problems. And then we have an annual reporting provision for the Attorney General. They have to do a public awareness campaign, working with these app developers to make sure they're in compliance. And we create fines. The Attorney General could sue on behalf of the state of New York for a maximum of $250 million. And lastly, the last component I'll mention is that there is a private right of action, which was very important to some of the stakeholders we were working with. Somebody could bring an action on behalf of a child user who has experienced harm from an online product. They could go for compensatory, actual, and punitive damages, injunctive relief, attorney's fees, etc. Understanding that the state is not necessarily going to be able to enforce all of this on their own. So that's a broad overview of the bill. We were very inspired by the California bill. That was sort of the genesis for this. But hopefully that was clear, and I'm happy to take any questions.
Thank you very much. Does anyone have any questions? We use the raise hand feature. Otherwise, I could.
Senator, I don't know how to use the hand feature, but I do have some questions. If you want to,
Okay, why don't you go? Thank you.
Just trying to find the button and I couldn't. First, Becky, thank you very much for joining in. I know we were trying to go back and forth on timeframes, and I very much appreciate you guys coming in, because it's very useful for us to hear what other states are doing. I had a series of questions. You addressed one of them, but I would like to ask a little bit more about the prior right of action in a second. But is there, in California, there's going to be rulemaking around, the Attorney General's office is going to be doing rulemaking around the age appropriate design code. Is there a similar function in New York? The bill, I should say, that you guys.
Absolutely. And I'm sorry, I think I'm not able to drop links in the chat because I think the chat may be disabled here, but it's S9563, New York State Senate, the name of my senator, which is also in my name up here in the Zoom, Gennardis. You can find it online. I think we have that in the last section of the bill, which is the effective date, but it's already implied in every bill that we write that the agency absolutely has the ability and the discretion to promulgate rules and regulations to effectuate the provisions of the bill. We are trying to sort of strike a balance between the legislature giving guidance on what we want the Attorney General to do, and then giving them the freedom and the leeway that they need to set a lot of this policy on their own. I do absolutely expect that there would be significant administrative action on behalf of the Attorney General, or if we change enforcement entities at some point, whoever's enforcing it, to be creating a lot of this policy themselves rather than the legislature doing it. And if you look at California and what they've done in the European Union with the GDPR, and the Children's Code is like a component of the GDPR, sort of, that's exactly what happened. The GDPR is a law that they passed the children's code is, it's called the ICO in the UK, who I'd be happy to connect anyone here with if they would like to chat more. The ICO takes that part of the GDPR that references the children's code and then creates the rules and the regulations and the policy that these data controllers and data processors have to follow.
Thank you for that. And if you want to send, I know you just sent me an email before you jumped on. If you want to send me the link in an email after you jump off, we can get that to Senator Maroney and distribute the bill
Okay.
link there.
Sure.
I can't purport to say I'm an expert on the California Age Appropriate Design Code. I think we're all learning a lot about that now, but a lot of the discussion after it passed, at least that I listened to and read, was on how websites would handle the knowledge standard around, I guess A is what is considered a child under your bill? Is it under 18 or is it under 13? Like what's the threshold there?
We did under 18. We wanted to make it broader. There are federal regulations with COPPA, Child Online Privacy Protection Act, I believe it's called, Children's Online Privacy Protection Act, relating to everyone under 13. We were very broad. We did 18, but we understand that like what I wrote was really a rough draft to get something out. We're going to have many, many revisions, many conversations with stakeholders, and we are probably going to need to revise the bill to treat somebody who's, let's say, 17 differently than you would treat somebody who is 13 or 9 or 6, right? So there's going to need to be some distinction. We put the onus on the entity when we say like knows or should know that your app, that your product is being accessed by children. And we purposely did that drawing from other legal language that is out there. And I think we're going to have to, that's one of the things that we're going to be looking at as we tweak the bill, is that standard and sort of how it's enforced. And who decides exactly what goes into that. I know in the ICO, which is enforcing the UK children's code, that is something that they are have thought a lot about in terms of like how is the app to know, and how do we make sure that they know?
Yeah, I think it's one of those issues I think people struggle with after California is, does the bill require like age gating of the internet? Right. I mean, is there some sort of like you have to have age verification before you get onto any website? I can't say that I agree with the doomsday prognosticators on that issue, but I think it's one of those issues that's really hard to figure out in these bills, is exactly how do you get it right on, if I'm a B2B client for a company, for example, like I'm not going to, but anybody, who has a website could in theory track somebody who's under 18, right? So how do you thread that needle of making sure that we get, that the bill attaches to the companies we want it to attach to, but doesn't create unreasonable burdens on companies that just have nothing to do with children under 18. I think at least that's something I think is still something we're trying to wrestle with in working through this.
If it's helpful, I can tell you what the UK is doing right now with the ICO, which is Information Commissioner's Office. They have the way that they enforce it, and it's a little bit different than our bill. It's like a complaint-based system. Somebody has to say this app is doing something wrong in some way, and then they go and talk to the app. They say that you either have to, 1, prove that there are no kids on your site, 2, apply the code regardless if you just feel like you can't tell, B, or thirdly, reduce the number of kids to say to below a certain significant threshold. And then he shared the definition of significant threshold with me, which I'd be happy to pass on.
Okay.
But that is the burden. All of this would be spelled out, I think, in the rules and regs that would effectuate the act. But the onus is on the entity to know when they're clearly targeting children or their app is being used widely by children.
Okay. And then just last question, I'll let other people, because I don't want to keep on dictating the conversation, but what is the New York process for, you mentioned before you're going to go through a number of iterations of this bill. You want to get something out to, probably for stakeholder and engagement, those types of things. What is your guys' process for getting bills through?
So we first you've introduced it and you get press on the bill, right? I don't know how it works in Connecticut. I imagine it's something similar. And what that does is it brings everybody out of the woodwork and all of the stakeholders that we need to talk to, right? I probably will be amending it a number of times and it will need to go through committee. And the standard for when it needs to go through committee, you know, there's a lot more eyes on that. That's where our Senate Majority Counsel gets involved. The bill needs to be a little bit tighter and more polished. Hopefully passes through committee, and then when it's ready, gets called up to the Senate floor to pass. And again, the standard there is even higher. So we'll probably undergo a number of revisions along the way. And then we negotiate with the assembly. We have, two chambers in our state legislature, and hopefully it passes there. And then we negotiate further with the governor in what's called a chapter amendment process, which gets kind of technical. That basically the bill gets signed and then a second bill amending the first bill gets signed at the same time. And then hopefully she signs it into law. I don't know that any of that is going to happen this year. I think this could be a years-long battle that we're all pitching. But it's like, for, like the bar is here for going through committee, then the bar is here for going on the Senate floor. And then there's going to be a lot of folks involved in this discussion. We're obviously going to be talking with the tech industry as well. We do need their buy-in. To an extent. So roughly that's the process. The bar for introduction is a little bit lower, which is why a lot of this stuff I just don't quite know yet. And we're still kind of figuring it out.
What is your session schedule? When do you guys open?
We have a half-year session in New York. So we are January through June. So it's pretty condensed.
Great. Thank you. And sorry, I asked one more question than I said I was going to.
No, totally fine.
Thanks, David. And let me just echo what David said. Thank you very much, Becky, for your time and willingness to come present to us. I do want to follow up on I actually had written down my question was to ask about the process in New York. So David, thanks for asking that. I do have another question. So in Connecticut, at the end of a session, if a bill doesn't pass, you have to start over completely the following year. How does that go in New York? Do you pick up from where it left off, or do you have to start over completely in the following year?
Yeah, like let's say this year I passed it through committee all the way to what's called third reading, which basically that just means it's on a list of bills where it's eligible to be called to the floor, because bills need to age 3 days, first reading, second reading, third reading. This next year it would go back to committee. I would have to pass it through committee again. Every 2 years, all of the bill numbers disappear and you have to reintroduce every bill. So our legislative session lasts 2 years. If you don't pass the bill that year, you start back on square one the next year.
Okay, so it's like us. It's kind of resets. It needs to go through the committee process. Okay. And David did ask a little bit about the knowledge. I did have a question on that, but it was just, I guess in the way it was written, because it just said if the website knows it's geared towards a child, but there's no it's not like a reasonable belief, or it just says no. So I'm assuming it's early on, so you're going to be working.
Well, we have to say, one of the things that we're going to change, like one of the revisions I'm going to make, I probably will just say should know, because one of the issues that's arisen in California and in the UK and other jurisdictions that have tried this is being able to prove actual knowledge is really hard.
Right.
I mean, on the one, I kind of think these apps do know who's accessing them, but they'll say that it's very hard. And so should know, now you're getting into things like design standards, content, who you're targeting. A lot of that, I probably will redraft it to have some of that guidance in the bill itself, but I am going to defer to the enforcing agency on a lot of it. So we're probably going to change the standard from knows to just should know, because that is what they've done. That's what they found with other jurisdictions that have tried this.
And I would appreciate a connection with the ICO you mentioned, if you would.
Yeah, they're great. They did not draft, just keep in mind, Sarah Maroney, they didn't draft the GDPR. They're just the regulatory authority. So like they're useful for policy concepts, but they weren't the drafters of it, but they're very, very helpful. Michael Murray is the name of the connection. I'll connect you.
Okay, great. Thank you. And one of the things I noticed from California, it appears that a lot of their stuff is going to come from the rulemaking process, which obviously hasn't gone in I think that's the rules are, and David probably know it. A lot of people probably know this better than I believe. Is it by next summer they're supposed to put out the rules, and then it goes into effect the following year. I did have a question on the, for a parent requiring access to accounts of a deceased child. There's no language in there for authentication. Is that something that you're considering, or?
Yeah, that's gonna have to be tweaked. That was some of the language was born out of very specific, very tragic incidents that have happened. Things like somebody being assaulted or killed on the internet and the video going viral and the parent can't take it down. Really, if you look at some of the press for our bill, it's really, really awful, some of the stuff. Some of the cases that, helped inspire this policy, we will probably have to tweak that so that the parent does have to verify who they are and maybe say why they would like access and what they're planning to do with that access, something like that.
Yeah. And I guess it just kind of, when you mentioned like the horrible circumstances, it just, remembering, and I believe today, is today the anniversary of, or we're coming up on the anniversary of the Sandy Hook tragedy, and hearing what the parents had gone through after, and that, people would call them and ask for their dead child and then laugh at them and say there was a hoax and those things. So I would just want to, obviously you want to give, if something is on their child's, site or the ability to take that down or create a memorial site, whatever it is, but you also wouldn't want people to be able to get access to put up, to put things that would be even more harmful, to the parents and to the memory of that child. So that's
yeah.
Let's see. Can you talk a little bit more about process to notify of emergence of issues, I guess, emergent issues?
Yeah, one of the things that we wanted to do with this bill that I think is maybe just general good public policy is we'd like to encourage compliance before fines set in, right? So I think what we were getting at there, we worked with a number of lawyers as well as tech industry experts and stakeholders, people who come from Google, Facebook, Silicon Valley in writing this. That appeared to have been an important component of, I'm just pulling up the bill and seeing where in the process, again, they have to notify. That's to help the app as they're developing, designing the product, have best practices and follow best practices. So that could be a child user, that could be a parent. Notification, I'm just looking at the language here. Shall create and prominently display a method for children, parents, and legal guardians to notify such entity of emergent problems. I think that's, again, just, meant to promote compliance, meant to make sure that they're being as safe as possible as they can with their child users and with the child users' data before there's a problem.
Thank you. And we did include, we did send out an email with a link to the bill. It just reminds me. But we will send that in a follow-up email to everyone as well, so that they have that. And I believe Kier Lamont has his hand raised.
Thank you very much, Senator Maroney, and thank you, Becky, for joining this task force and sharing on this really interesting bill. One question that I had when I was reading this bill earlier and kind of comparing it to the California Children's Age Appropriate Design Code is that it seemed like the approach to data protection impact assessments was a little bit different. And as I was reading this bill, it seemed like the intent was to conduct a data protection impact assessment for any new online service, product, or feature kind of directed towards children, which would then have to be transmitted to the Attorney General's office and then approved in order for that product, service, or feature to be made available. And if I understand that right, could you describe a little bit more about kind of the intended procedure there? It does seem like that could result in the Attorney General's office receiving hundreds of thousands, millions, I don't know how many risk assessments they would end up getting. And if there's a backlog, that could slow down the development of new features, was something that seemed like a potential concern to me. So I was just wondering how you saw that process kind of working in operation.
That is an excellent question, Carrie. The minute I introduced this bill, I got a call from the Attorney General's office saying we absolutely cannot do this. And I said, don't worry, it's just a rough draft. I either had to house it in enforcement in your office, or I had to create an entirely new agency to regulate the internet that does not exist in New York State. And that's something that you guys might have to do in Connecticut as well. Basically, I had them play like a pre-clearance FDA role, but we're definitely going to have to change that. They do not have the ability to do that. These DPIAs, data protection impact assessments, that was a practice and a policy principle that we again pulled from the GDPR, General Data Protection Regulation of the EU. But apparently, according to the ICO in the UK, they're like really onerous, and a company like Meta might have 30 different DPIAs, and they get really complicated, and there might be a totally different and better route to doing all of this anyways. So we may switch to what the UK Children's Code does, which is it's a little bit more complaint based. They're trying to go after, I don't want to say the worst actors, but or like the biggest fish, the ones that are collecting and processing the most children's data that are the highest risk and present the greatest risk to these children and to the public, rather than every single app, website, service, et cetera, being cleared before going to market. That is how I intended it when I wrote it, but then I think we will very likely have to change that when we look at actually passing it.
That's extremely helpful. Thank you.
And one thing, just to follow up on Kira's question, is it did appear that these rights would be required by everyone. There's no threshold for size of a company, so it's just any product that you have a reasonable belief could be targeted towards children would.
Yeah, but again, if we were to switch, the way that is solved by switching to a complaint-based or a highest risk-based model is then you're giving the agency the discretion, right, to figure out who they're going to target. And so that I think possibly by switching the administration of the enforcement of this kind of policy, you solve a lot of those threshold and capture problems where no, we can't possibly go after everyone, and we may not be able to, and maybe that's fine for the day,
Great. Thank you very much. Are there any other questions?
Senator, can I just one follow-up? I thought maybe somebody else would ask it, but you have a private right of action in this bill, Becky. So, that's a big bell to ring. Can you talk through the considerations in adding the PRA and whether you think it's something that will stick until the end?
So one thing you'll notice that's one of the biggest differences between our bill and California's. California does not have a private right of action. I think that was coming from a place of feeling like even if we switch to a complaint-based model, it may be infeasible for any kind of state agency or entity to be able to fully enforce the provisions of a bill or a policy like this, and feeling like this could also be enforced in the civil court system. I could definitely see there being discussions on this. I could see that private right of action being a little bit contentious. But again, we were looking at sort of some of these worst case scenarios and enormous amounts of harm that children have suffered in certain situations from these apps, and felt like it was an important policy component, at least to start the conversation with. But I do think that will be a point of discussion for sure, as private rights of action frequently are, I would say, in New York State legislation.
Thank you very much. Are there any other questions? Good. Becky, thanks so much for your time. Are you okay if we put your contact information in when we send out the copy of the bill in case anyone has follow-up questions for you?
Yes, also happy to join in the future if you guys want updates, if you want to share the work that you're doing. Happy to connect you with ICO, who's been very helpful. Yeah, absolutely happy to share my contact information in the chat, and I would chat with anyone on this call as well about the bill, if they would like.
Great. Thank you so much.
Thank you. Okay, bye.
Bye. And so, next, here is Bailey. Is Bailey Sanchez on from Future of Privacy?
Do I have screen share ability? Do you know?
Sam has to give it to you. So Sam, can you please
No,
make sure?
Bailey, you should already have it. It should be on the bottom of your option screen, where it says share screen. It should be in green.
Awesome.
Mhm.
Are you seeing my screen?
Yep.
Yes, we are. Thank
Perfect.
you. Thanks, Sam.
Okay, so switching gears from children's codes a bit, I was asked to talk about the child privacy provisions in the American Data Privacy and Protection Act. So I am Bailey Sanchez. I am a policy counsel on Future of Privacy Forum's youth and education team. So a very significant part of my portfolio is tracking state and federal legislation and really looking at trends on the youth and education side. So just a little bit of background on the American Data Privacy and Protection Act. So a lot of the activity took place this summer, and it has not yet passed, but it is an ongoing process in Congress and something we expect may inform privacy legislation in the 2023 debate. So why am I talking about ADPPA? Why is it significant? So it is a bipartisan, bicameral federal privacy proposal that would regulate a broad scope of covered entities, including nonprofits. So this is regarding the collection, transfer, and processing of personal information. So this is the furthest a comprehensive federal privacy bill has ever gotten. And while it appears unlikely that it's going to be enacted this Congress, the enthusiasm and momentum behind ADPPA is just a big moment for privacy legislation and something that might inform state lawmakers in the coming years. So it did receive bipartisan support, overwhelmingly bipartisan, and the bill also represents a compromise between parties on two longstanding issues in the privacy debate. So it combines FTC, Attorney General, and a limited private enforcement with subject area preemption, and it would preempt most provisions of state comprehensive laws, but it preserves many state-specific laws. So that is a bit of background on the bill itself. So diving into the content. So I mentioned my focus is on child and student privacy within FPF. So when looking at consumer privacy legislation, usually the very first thing I look for is what age threshold the bill uses and if there's any distinction made between age groups. So are very young children treated differently than teenagers? Because sometimes we see a category for adolescents or specific provisions that only apply to teens. So here, ADPPA defines a covered minor as being under 17. This is a deviation from COPPA. Becky just previously talked about COPPA a bit, but COPPA uses 13 as a threshold. But this is consistent with a trend we've seen over the last several years to raise that age limit for minors who are given special protections aimed at children. So parts of this bill have been borrowed from other federal bills solely focused on kids' privacy. I'm not going to talk about those today. FPF has a policy brief that gives an overview of 4 federal child privacy specific bills. But there are 2 bills, the Kids Online Safety Act and COPPA 2.0, that kind of have some traction right now. So there are a couple places I might call out, like where ADPPA borrowed from those bills. So here, ADPPA aligns with the Kids Online Safety Act and using under 13 as a threshold. So another definition that's very important to note here is what knowledge standard the bill uses. So Becky just talked a lot about knowledge standards. So COPPA applies to operators of websites or services directed to children, and it also applies to operators of websites or services not directed at children, but who have actual knowledge that they are collecting information from a child under 13. So one of the most interesting things about ADPPA to me is that it uses a tiered knowledge standard. So there are actually 3 different tiers of knowledge standards for children, and that's not something that I had previously seen in any state or federal proposal. So I have pulled out the relevant language so you can take a look for yourself, but really the gist of it, working from largest company size to smallest company size, is that covered high impact social media companies would be subject to a constructive knowledge standard. Large data holders would be subject to a new or acted in willful disregard standard. That willful disregard standard may sound familiar. That's what's used in the Connecticut law. And then all other covered entities who are not one of those 2 groups would be subject to the actual knowledge standard. So similar to what is under COPPA. So I pulled out the definition just of covered high impact social media company for you to look at, but the large data holder definition kind of follows a similar approach of defining size, not just as like the number of users, but also giving a revenue requirement. It's just a little bit lower of a revenue requirement and a little bit less users. So with those 2 definitions in mind, I'm going to walk through the actual provisions of the bill. So like I mentioned, this is a broad, comprehensive consumer privacy bill, and there's one section that pertains to children specifically. So throughout this section, you are going to see wording like has knowledge or knows. So the determination of what that would mean for a company complying with this bill would depend on the definitions on the previous slide and kind of where they slot into those revenue and user requirements. So the first big thing for children is a prohibition on targeted advertising. I've pulled out the language here. It's in italics. So this is a pretty clear-cut ban on targeted advertising to anyone under 17, depending on what knowledge standard you'd have to comply with. The bill does define targeted advertising, and it also makes clear that contextual advertising would not be included in that definition. So just comparing this with Connecticut's language, Connecticut has a section on targeted advertising where a controller has actual knowledge and willfully disregards that a consumer is 13 to 15 years of age. The controller shall not process that consumer's personal data for purposes of targeted advertising, nor sell the consumer's personal data without the consumer's consent. So here there's not really a distinction made between adolescents and very young children. Additionally, there is a prohibition on transferring a minor's data to a third party without express affirmative consent. That affirmative express consent can be obtained either from the covered minor or from the covered minor's parent or guardian. You'll see here there's not a distinction made on what age a minor could consent for themselves. Presumably, it would be 13 and up because of COPPA. But it's not specifically addressed. And then additionally, an exception was added related to child safety and law enforcement. So moving on to the other parts of the bill on enforcement and safe harbor program. So ADPPA would establish a youth privacy marketing division within the FTC's Privacy Bureau. This is borrowed from COPPA 2.0 and one of those other federal bills. This division would be charged with addressing the privacy of children and minors, as well as marketing directed at children and minors. This division would also be charged with submitting an annual report to Congress on a description of the work of the division regarding emerging concerns related to youth privacy and marketing practices, and an assessment of how effectively the division has assisted the FTC in addressing youth privacy and marketing practices. Another interesting thing to note here is that it would require the FTC Inspector General to publish a report evaluating the Safe Harbor program under COPPA. So COPPA provides for a Safe Harbor program where industry groups self-regulate. Safe Harbor programs are required to demonstrate mechanisms for ensuring compliance with their guidelines, such as annual review and disciplinary protocols. So this report would require the Inspector General every 2 years to evaluate those programs for fairness and effectiveness, as well as recommendations on how to improve the program. And this is also borrowed from COPPA 2.0. So just some other quick provisions to note. So the 2 previous slides are really all it says specific to children, but in looking throughout the bill, there are some additional protections for children and things to note. So on preemption and preservation of existing laws, so ADPPA would not amend or alter the federal frameworks set forth under COPPA or FERPA, and the draft section on preemption preserves state laws that govern privacy rights for students and protections for student information. So it is possible that depending on what is in a children's code, that could be preempted, but student privacy laws certainly not. And then there also are a couple of provisions that apply to sensitive covered data. So children are included in that definition of sensitive covered data. So because of that, covered entities cannot collect, process, or transfer sensitive covered data without the affirmative express consent of an individual. So essentially opt-in consent. And then there is another section within the bill that includes a right to withdraw consent that must be as easy to execute as the means for providing consent. So that should also sound familiar because it's contained within Connecticut's privacy law. And then something to note a bit more on the education side than the kids side, but certainly worth calling out, is that consumer privacy laws, they often exempt nonprofits, but ADPPA includes nonprofits in its scope. So while public K-12 schools and institutions of higher education are specifically exempt in the bill, as the bill is currently written, private K-12 schools that are not receiving funding from FERPA would likely be subject to ADPPA compliance. So that would be the first time that a private school would have to comply with this type of law. So I pulled out some facts on Connecticut just to kind of give you like a frame of reference for what that would mean. So for the 2022 to 2023 school year, there are 408 private schools in Connecticut and 996 public schools. Obviously, the difference in number of students being served is quite different. It's 63,000 versus 496,000, but a pretty substantial number of private schools. So in effect, this would mean that the data of children outside of school and of private school students would be classified as sensitive and subject to the most heightened protections, but those public school student records would continue to be regulated by FERPA. And then just another like frame of reference for you is that 90% of an EdTech vendor's customers are public K-12 schools, but 10% of their customers are nonprofit private schools that do not receive funds from the Department of Education. So that is really it on the like key provisions that apply to children in ADPPA. I did provide some additional resources. I know I was asked to talk about ADPPA, but FPF actually has two really great resources on the California Age Appropriate Design Code. So I've linked them here, and then I'm happy to take any questions.
Kelly, thank you so much for your presentation. I see David has his hand raised. So David.
Yeah, thank you, Senator. Bailey, thank you for coming on and providing this slideshow presentation. I'm sure the Senator is going to ask you to circulate that around as a resource. It'd be fantastic. I know one area I struggle with this issue is drawing distinctions between like how the ADPPA approaches this issue versus how California is approaching this issue with the Age Appropriate Design Code. I gather you really looked hard at both of these. Is there some like high level takeaways for how those two, like one a law, obviously one just a bill, are tackling this, and whether you have thoughts on which way is better or not, or whether there's aspects of those bills that are more preferable than others?
Yeah, that's a great question. I don't think we can really say at this point whether like one approach is better or not, especially because the California bill isn't going to take effect for a couple of years in the UK. It's still fairly early on in its compliance journey. I mean, a significant difference between the two approaches that the California one is focused on kids' privacy, kids' design, really kids' safety, and then the ADPPA is a comprehensive consumer privacy bill that is going to give privacy protections to not just children, but to everyone, but then giving like heightened protections to children. And then I know that the age appropriate design code did strive to kind of like strike a balance between regulating very young children versus a teenager, because I think we can all agree that like a teenager's experience online is going to be fairly different from a 7-year-old's. But the way that shook out is that it was just in kind of the legislative findings, like, hey, we have different groups of children at different developmental stages. Take those to account, but that is in the legislative findings and not the actual text of the bill. So I think a trend that we're seeing and something that FPF thinks is smart legislation is to really have a distinction between young children and teenagers, and as you get older, to have a bit more autonomy and have privacy rights for yourself versus like, you know, the parent control for a 16-year-old's privacy rights.
Thank you for that. One follow-up on that one is the same question we were asking Becky about. And I just, you know, again, at post age appropriate design code, it seemed like there was a lot of talk on this, and like Angelique's podcast had a couple of people on this one, like this knowledge standard, right? I mean, how do you thread the needle of enforcing this and having the companies that are in fact targeting individuals who are younger than a certain age comply with it versus having like age gating of the internet, right? Where, you know, I mean, I guess the criticism was on the age appropriate design code is like, now you're going to require every website to like age gate. Now you're collecting more information than you were on individuals, you know, through like, you know, facial recognition and those types of things. I'm sure you've listened to the podcast, I'm sure, and appreciate these issues. Any thoughts, if you looked at this issue, about how to thread that knowledge standard appropriately?
I think that's really the question on everyone's minds. We talked to a lot of different companies and different stakeholders about this issue, and it seems like everyone is kind of looking around like, what is the magic solution? Because the challenge is that to do age assurance or age verification, you are necessarily collecting more data than you might otherwise. But then at the same time, there are principles to have data minimization. California, I think, tried to strike this balance by saying, if you were going to collect information for age verification, do not use it for any other purpose. So I think that is one approach to this. But in terms of the actual methods of getting it done, I think it's a challenge that I don't think I have the answer to, and one that like a lot of even very large companies are still like actively thinking about.
Thank you again.
Thanks, David. Are there any other questions? I'll ask a few while we wait for someone else to raise their hand. So now, I think onto that issue of age verification, I think there was a proposed children's bill in Connecticut last year where we did want to look at requiring some universal form of age verification. Are there accepted methods for age verification, and how has the UK approached that in their age appropriate design code? I mean, is it through a reg process or a process that they'll, you know, validate certain methods?
Yeah, so we also have talked to the ICO a fair bit, both people that currently work there and those that like kind of were the architects behind the age appropriate design code that have since moved on to other opportunities. They provide a lot of like guidance and recommendations for how to do that age assurance piece, but not a lot of like very concrete, like this is how you do it. It's just like considerations to keep in mind. I know the UK has an age check certification scheme. So there is kind of like a certifying body that has handled this, that has been approved by the ICO. But in terms of like specific methods, I think that's still an ongoing process. I do know that kind of like a leader in the UK space that has partnered with Meta is Yoti. That is who Meta uses for some of their age verification. So Yoti uses a kind of facial recognition base. So it's not verifying that like I am Bailey, it's verifying that I am, I'm 28 years old or I am between this range. But obviously there's still like some level of privacy risk with any method you're going to use.
Thank you. Now, we talked about the ADPPA, and they have the split levels, right? 3 different levels or thresholds for knowledge. So the highest level is for social media companies that generate a certain amount of revenue, right? Is that, I mean, how many right now, how many places would fall under that threshold? And so would that mean then that it's purely social media? So if you were a large e-commerce site, you wouldn't be subject to that highest threshold. It would be a different threshold.
Sorry, I'm just trying to pull up the definition now so I can take a look at it. Yeah, so it's covered high impact social media companies generating more than, what is that, 3 billion in annual revenue and has a 300,000 or more monthly average users for not fewer than 3 of the preceding 12 months. So I think the combination of users and revenue, that's not an uncommon approach to trying to like define like a large company versus a small company. I think the challenge, though, is that sometimes you can have a very, very popular social media company that just is not generating that level of revenue. So I haven't had any occasion to talk with the drafters behind the bill recently. Like, I don't know if the intent is really to target those companies that have both pieces, or if they would mean, like Snapchat, I think in the first 2 years didn't have any revenue. Like, is the intention to include Snapchat here or not? Or is the intention to include really the very largest and the most profitable companies? So I think there are trade-offs to the approach.
Right. I mean, that's an excellent point. And that if you want to get things in the beginning, they're not going to have the revenue threshold. So they won't be, while they're starting out, they won't be subject to those regulations. And I would assume, I guess, that high impact social media companies defined somewhere else in the bill. I'll look at that, because it's hard, because even e-commerce sites have a somewhat of a social component with reviews and things. So I guess how you define it, everything in these is all in the definitions.
Yeah, it looks like it's platform is primarily used by users to access or share user generated content.
That's right. That's what's okay. Thank you. Paul?
Hi, Sanders. Sorry, I'm not on the video today because I'm actually traveling. But just wanted to give you one other data point on that. Outside that category of the social media platforms, there's also the large data holder, and as been described, the bill applies to all, a whole range of businesses. So just from the retail perspective, the definition of large data holder also needs some work, because it would currently reach, it's not just the largest, internet platforms that you can think of. The way it's defined and the thresholds reach down to include about 2,000 different retail companies across the U.S., some that are really not that very large. And that's due to the fact that retail, of course, sells, groceries and goods in great volume. And so hitting the 250 million volume, you're talking about, the top, 1,800 or a little over retailers in the country. And so it's, to get to threshold levels that would just be limited even to the top 100 retailers, the threshold would have to be as high as $1 billion. So there are $1 billion in revenue. That's not profit. That's just the amount of sales and volume that happens at the retail level when you're talking about the top 1,800 brands in the country. So most people probably couldn't even name the any brands in the 1,800 slot. So the knowledge standards really need to be thought through, given the breadth of the definition of large data holder as well. And it could impact a lot of potential, websites or apps that are not intended to target children, but where you might anticipate that children could potentially, shop or download an app or something. So there still needs to be more work, at least from the retail industry perspective, on that definition of large data holder and how that flows through on the children's privacy stuff. So I just want to give you that perspective.
Thanks, Paul. David?
I just wanted to ask Paul is Dave Stous. I just wanted to ask whether you guys have offered some sort of written comments on the ADPPA's knowledge standard that'd be useful to look at, that you'd be willing to share.
We haven't offered written comments on the knowledge standards here. This is more a concern over the definition of large data holder, and we've raised those issues with staff, but I don't have anything I could share on that yet. I don't think we've settled on language that would address the concern.
Okay, thank you.
Thanks, Dave. Thanks, Paul. Are there any other questions for Bailey? Okay, Bailey, thank you very much. And are you also, will you send us your PowerPoint so we can share that out with the other resources, as well as, are you all right with us sharing your contact information?
Yeah, definitely. I can definitely shoot you an email with the PowerPoint and contact information. And then the PowerPoint will have those additional resources that I mentioned.
Great, thank you so much. So, thank you again, Bailey and Future of Privacy Forum. Next, well, let's see. Nicole, are you ready to go now, or would you be okay if I had the Michelle Lucan from the AG's office talk for a few minutes?
We are ready to go, and if you don't mind if we go right now, we have Baroness Kidron with us, and only for the next 15 minutes or so.
Oh, okay, great. So why don't you go? Then.
Okay, wonderful. Thank you. So thank you so much for
Thank
inviting Five Rights to be here today. Five Rights is an international NGO dedicated to creating the digital world that young people deserve. And I am happy to answer all of the nitty-gritty details of the California Code. But before I go into those, I would like to introduce Five Rights founder and the lead architect behind the UK Code and the California Code, Baroness Kidron. She is a crossbench peer in the House of Lords and a fierce advocate for children's rights in the digital world. And like I said, we have her for about the next 15 minutes. So please make sure to ask all of your questions about the UK AADC, the ICO, GDPR, and all of those things. Baroness?
Well, thank you very much. I always like being introduced as fierce. That's a worry right there. And I really appreciate being invited to this meeting, given that I'm here in London. And that is, in fact, why I'm not spending longer with you, because it is nearing the end of my day rather than the beginning. I hope that this is going to be useful to you. I'll just, if I outline why we did the code, what the code does, what we're seeing, and then I'll stop and hear where you're at, because I did come in on the conversation and I can hear some anxiety in the background. So I'm really interested to hear what people are thinking. So first of all, when the Data Protection Act came to the UK, and it was part of the whole settlement of leaving the EU, et cetera, we had our own updated data protection law. I realized that children were rarely mentioned, and that was very problematic. And I actually sat down with a number of other concerned folk and thought about what would it be like if we had standalone protection for children, and really to describe how much privacy impacted on safety. And how could we tell that story in legislation, which is a sort of an unusual thing to do, but we did it. And the three things that I'd point you to right at the beginning, the first was that we found it unacceptable that the age of adulthood online had become de facto 13. Most parents, brothers, sisters, and in fact children themselves know that they're not adult at 13. And so creating the age limit of 18, which is how we did it, was using, in fact, the Convention on the Rights of the Child, and invoking Article 1 was how we did it in UK law. But actually, we've watched it seeping around the world now that the age of children is gradually becoming 18. We're seeing some 14, some 16, but more and more we're seeing 18 as a default. And so we think that that was one of the most impactful things that actually happened through the code. The second thing that we did was we actually really thought about default settings and about how powerful default settings are. And so everything in the code really looks to the provider to set the default setting in favor of the child, as if they knew it was a child. And so that doesn't mean that children cannot do things. They can actually often change settings, yeah? But rather than the default being open and you close it down, the other operating model. And that has been immensely powerful. And I'll come to that. And then the third thing, which again, I'm sure you've spoken about, is this concept of directed at children. Now, in the beginning of the digital world, directed at children made some sense. You know, you think of Sesame Street, you think of things that were directed at children. Actually, as the digital world became the place where they do their education, their health, their relationships, their entertainment, the directed at children stop making sense. And especially if you think of a child as anyone up to the age of 18, most children spend most of their time in environments that are not directed at children. So we came up with this idea of likely to be accessed. And I think I can probably leave to Nicole to show you the exact way that we get to likely to be accessed. But I really want to make the point that it was to make sure that no company was sort of held to account, feet to the fire, for having the odd precocious child, you know, in their environment. That is not their fault. We're talking about the routine nature of the presence of children. And there is we have had some success with the ICO of testing what their own version of likely to be accessed, because we made them change their mind on something about what likely to be accessed by showing independent research. So those are the three big things that I would point with you, and they've been very, very shape-shifting, as we like to say in Europe. The standard itself, the regulation itself is, I'm sure many of you, you're a very expert audience, many of you will have seen it, but it's 15 different standards. And I think the important thing to say to you is that they're not conceived as independent pick and mix. They are, you know, they are interdependent. And so if you say, for example, data minimization, well, that gets you so far. But if you also then say GPS off, that gets you so far. Then you say, don't nudge a child into lowering their privacy. That gets you further. If you don't share it unless it's in their best interest, that gets you further. And what happens is that the decisions that the companies make on the basis of doing a risk assessment against those 15 standards adds up to answering the question, what would you do differently if you knew the end user was a child? Yeah. And that is really the philosophy. And I have to say that this is not about weighty regulation. This is about, have you checked with the right thing in mind, you know, with the child in mind, that you have done the things that would actually protect the privacy and safety of that child? And that is what happened. So what happened when the law came into effect in the transition period, I mean, hundreds and hundreds of changes, but if I say Instagram and TikTok both stopped direct messaging of children from unknown adults. Yeah, because by the time they went through that series of things, they realized it was unconscionable to allow that to happen. YouTube turned off autoplay by default. Hugely impactful. And I have to say, just as a personal aside, I spent years trying to persuade YouTube to turn off autoplay for kids. And it was just one of many things that they did. Google made safe search default browsing for children. And then TikTok have recently made accounts for those under 16 private by default. They've also stopped the monetized exchange of gifts between between adults and children and so on. I won't bore you all with the whole thing, but the raft of things has really been the biggest redesign we've seen, for children since the get-go. So I think the thing that I'd like to finish with is to say, this is supposed to be, I know it didn't always seem it with some of the conversations I've had with tech, but actually I've had a lot of very positive conversations, and it's supposed to incentivize best practice. Yeah, it's supposed to incentivize people to imagine the child and to take the problem out of the system rather than dictate. And I think, I don't know, whether this is a European kind of way of thinking about it, but I know that colleagues in California struggled with it and then loved it, which was that actually it's completely tech neutral. Yeah. It doesn't say how you've got to get there. It says, this is where you've got to get, please go there. And then the AG, in the case of California, the ICO in the case of the UK, will be the determiner of whether you got there okay. So, and I think the reason for that is it allows for proportionality, it allows for creativity, and most importantly, as future-proofed. Yeah, you can take the same set of principles, the same set of standards against any possible thing and say, hang on, is the outcome for the child okay? So let me possibly stop there, because I think that's probably, the intention. And if anybody's got any questions, I'll be really happy to answer them.
Thank you. First of all, thank you so much for being here and taking some time to speak with us and for your presentation. So let me open it up to see if anyone has any questions. And then, when did this go into effect, and how has it been? I mean, you mentioned some of the would seem like successes so far, but how has it been going so far?
So I would say that it's been, as far as it's been very successful. It came into law it was put into the legislation 2018. It came into effect 21. So it's only been actually in effect a year. I think that we are seeing some really interesting compliance cases coming through now, because it takes a while to get those, as you all know. And there are 2 or 3 things to say about that. One is that both we, Five Rights, and the regulator separately, because we're not sharing any, we don't share any governance or space, have taken the view that compliance is more interesting than punishment. And so a lot of companies are actually doing a lot of work on compliance and coming to us and saying, is this good? Is that bad? If we did this, would that make you happy? And I know they're doing that with the regulator too. So we've got some really interesting conversations going on at the moment, particularly amongst the gaming community. Yeah. There are also some people who are blatantly ignoring it. And I know that the ICO has about 20 cases at various points of thing, but 5 cases that they're expecting to speak on, in the coming weeks and months. So actual things. And we are looking ourselves, as are other people in the community, at taking some complaints to the courts. Now, on the whole, that's not what Five Rights does. We do act sometimes as experts for other people that do, but really we are keen that there be a minimum of that there will be some legislation just to set what the bar is. So I think that over the next months, couple of years, we're going to see where the floor lies, but we're expecting a lot more copycat compliance. And what I mean by that is that when YouTube turned off autoplay, so did a number of other smaller companies. Yeah. As soon as they did it, the others did it. And I think that we're expecting a couple of things of great impact like that will go through the ecosystem. And maybe the other interesting thing I could say about that is that the vast majority, I don't have a figure, but really probably everything we've seen has happened at a global level. Yeah. So even though it's a UK law, they are making these changes across the world, and our interest in having other jurisdictions, pick up a very similar or the same approach is that then we actually have a lot more support for compliance and for raising that bar and for taking taking action and making that actually the standard, a standard, which is obviously a holy grail for all of us, on something that knows no boundaries.
One of the things that, actually, let me let David go. David has his hand raised, and then I'll follow up after that if there's still time.
Thank you, Senator. Thank you for coming on and sharing your experience. One thing that intrigued me in your comments was your work with California and the age-appropriate design code. Could you speak more to that process by which you were able to work with the California lawmakers to design something that worked for California? Because there are differences, right, in the approaches between that. I think that would really educate the Connecticut work group on sort of trying to thread this needle, which everybody is sort of trying to do right now.
So I'll just talk a little bit to the politics of that, and then I'm actually going to hand over to Nicole for the practice of it. The politics of that was that a number of people in California rang me and said, we are really interested in data protection. We're really interested in children, and we're really interested in what you did in the UK. What did you do? Yeah. And so as a result of those conversations, the first of which was with Buffy Wicks, I said, so long as it is on a bipartisan basis, I would be more than happy to come and work with you and your colleagues to work with your process and try and understand what you would need to get to the same place. And the reason that, that I put it that way was that it is in my opinion, the biggest interest I have is that kids all over the world, not just in Connecticut, not just in California, and certainly not just in the UK, but right across the world, and we are working with Africa and South America and so on, have a similar high bar of privacy. And so what I was suggesting to California colleagues was, obviously you have to get there in a way that suits your legislative pattern. But could we agree that we're trying to get to the same outcome? And that was what we agreed to do. It was bipartisan. I did work with all the politicians in trying to explain it. And now I am going to seamlessly hang over to Nicole, because my greatest cleverness was actually whipping Nicole out from her previous job and getting her to do this work, because she was absolutely brilliant and dedicated on that path.
Okay, well, so I will just say thank you. So I was with the California legislature for about 10 years before joining Five Rights. I was with the Senate Judiciary Committee as policy counsel, analyzing legislation affecting children and privacy for about 6 or 7 years. And then I switched over to the Assembly Privacy and Consumer Protection Committee, where I was the chief consultant doing privacy issues over there. And that's where I really started to do more tech policy. I'm an attorney by trade. Age-appropriate design code, I was actually with the Privacy and Consumer Protection Committee when that came through, and that is how I met the Baroness. And I loved working for the legislature. I wouldn't have just left for anyone, but the age-appropriate design code, as I think all of you are seeing, it was a real paradigm shift, and it was really inspiring. And so my first job in looking at that legislation was to take something that was written for the UK. It was written to, work with GDPR. It was written to work with the UN Convention on the Rights of the Child and take it and make it into something that could work in the American legal landscape and could also work in California. And so worked with lots and lots of stakeholders, mostly from industry. We worked with absolutely everyone who came to us. And, the first order of business was to try and take British English and turn it into American English, as I say. One of the ways we did that was by incorporating the definitions from California's Comprehensive Privacy Law, the CCPA, into the age-appropriate design code. And, stakeholders were thrilled with that. They were familiar with those definitions. They had been well vetted. They were already compliant with them. After that, we everyone on this call is going to love this, but the prosecutors and industry stakeholders both wanted more prescriptive language in the bill. They said we need something not only for compliance, but for enforcement. And I've never had industry and the AG ask for the same thing. So we did that, right? And this is how we started getting the bipartisan support. We really worked with all stakeholders to make sure that this is something that was practically feasible, but also that the 15 standards that the UK code are based on were present. So most of the negotiations and most of the amendments came from trying to really ensure that business and industry had a similar compliance burden across the two countries, because most of these companies are operating globally, but also that the 15 standards to protect children were available in both. And I've been listening to the conversation today. I'd like to start answering maybe some of the nitty-gritty questions about the business threshold likely to be accessed, how we're going to clarify things with rules and regulations. So please, I'll just start going through the list, but if anyone has any additional questions, absolutely happy to answer. So I'll say first and foremost, this is a design law. This is a classic products liability law. It says that, before you offer something to the public, you need to identify any risk of harm and do your best to eliminate or mitigate that risk of harm. This is not a law about waiting for the harm to happen and then suing after the fact. This is the violations of the law are violations for not doing the design the way you were supposed to. We don't need to wait for a child to actually be harmed. I think from a public policy perspective, that's why it's appropriate that it's enforced by the AG and there's no private right of action. Clearly lots of stakeholders love that there was no private right of action, but that also, I think from a public policy perspective, makes sense. The directed to children standard in COPPA, as we've been talking about today, I think a lot of people recognize that while it made sense in the early 90s, it doesn't make sense today. The internet has changed, the internet has grown, the way we use it. And so we need to have a different standard. So we worked extensively with stakeholders on the likely to be access standard in California. And it's not, the standard does not cover any website where there's, one or two kids who are hitting up that website. You have to be routinely accessed by a significant amount of children, routinely accessed by a significant amount of children. The reason we said significant amount of children and not a majority of children is because we know that teens and children are hanging out on websites and apps that are intended for a general audience. So a significant amount of children was important and able to capture YouTube, capture Facebook, capture these other places. Does barnesandnoble.com come into this? Only barnesandnoble.com knows that, but if they ask the question, is there any risk of harm to children from our data privacy practices? And, what can we do to keep kids more safe if they are coming to our website? Then at least in California, and it could be different, if different states adopt this and amend it based on their own needs, but they get a 90-day right to cure if they're in substantial compliance with the law. So substantial compliance, as defined in California, means that you did the impact assessment. And so if companies are asking the question, they get a lot of benefits. The data protection impact assessments have also come up a lot. We worked in California extensively with industry stakeholders to make sure that they were as least onerous as possible, right? So you can have one impact assessment to cover various features so long as they are similar. If you have to do an impact assessment to comply with another law and it meets the standards of this law, you can use the same one. We made sure that the attorney-client privilege was protected. They're not subject to the Public Records Act. There were a lot of things we did with industry to make sure that it would work for them. I talked about the business threshold. So stakeholders requested that we incorporate the definitions from the CCPA. And so the definition of business is in the CCPA. It is for-profit businesses only. They're large businesses. You have to have an excess of $25 million or buy and sell the personal information of over 50,000 or more consumers. So it's not hitting the smallest of businesses. There has also been some conversation today about the role of the Attorney General and the rules and regulations. So I just want to clarify that a little bit. So the Attorney General in California is the enforcer of the bill, and they have the permissive authority to issue regulations to clarify the requirements of the bill. But the task force, the working group that is set up by the bill, they are not issuing regulations. They are studying certain questions about the implementation of the bill and giving recommendations to the legislature for further legislation. So they're not, the working group is not issuing regs on their own. And there's a fair amount of language in the bill that says, please look to the ICO, please look to the lessons that we're seeing from other places, around the world, because we are trying to create a global standard. Let's see. Oh, one more thing I wanted to talk about is the age verification requirements. They're not age verification. The bill requires age estimation, and it is based on the level of risk. And so the example I like to use, and the Baroness always does a great job with examples of this, but if you're a dating app, right, the risk of harm to minors who go on that is significantly higher, maybe than, a minor accessing wallstreetjournal.com. And so any sort of age estimation would need to be different. It would need to be proportionate. And there are many, many ways that you can do age estimation. It does not mean identity verification. But if the risk is very low, it could be as simple as self-attestation. If the risk is higher, it probably needs to be something more. And if a website or app that is likely to be accessed by children makes their product safe for all users, there's absolutely no need for age verification at all. And I see the Baroness has her hand up, so I'll stop talking for a moment.
So I was just going to add a couple of things to what you said, and thank you for that, Nicole. One is this is at the moment the jurisdictions that have passed this, so the UK, Ireland have done it, and California, and we're actually expecting probably another half dozen countries, maybe even more by the end of next year. But I want you to just also know that a few organizations have contacted us and said that we can't wait for our country, and we're going to start applying it to our own international organization. And that was really interesting move. I'm not suggesting it's the answer, because I like things in regulation legislation with people with oversight. That is my preferred method. But I think that I wanted to say that because the second thing I want to say is that the reason that it's designed around a risk assessment is if you find no risk, you have nothing to do. Yeah. If you find little risk, you have little. So your effort, your regulatory effort, is designed to the amount of risk. And I feel very unembarrassed about creating regulatory effort for people who are putting children at great risk. And I would not wish to put anybody at too great regulatory effort if they're not. So I really wanted to emphasize that piece. And that is why we've had very productive conversations with the tech companies. And then the last thing I will say, which is really around this concept, which is the first of the 15 standard, is that you must act in the best interest of the child. When that first came in, everybody went a little bit bat crazy, yeah, because they go, what is that in law? Yeah, I mean, really, like, it was very disturbing. I just have to say, I have had dozens of conversations, scores of conversations with engineers in Silicon Valley and outside, and they go, we love it. We love it. We've always just had growth engagement in that space. Now we've got best interest. It's an A-B question. We're designers, A, B, A, B, A, B, A, B. We make a series of decisions. And if you ask yourself, is this decision this incremental decision in the best interest of a child? You normally know the answers. And And I think that we are increasingly, we've got case law outside of the tech sector on best interest. And then, but I just want to say that not everything that is absolutely pinned down is the most powerful. And I think that I just did something with Jimmy Wales, who you'll know as the inventor of Wikipedia. And that is a very good example too. It is in the best interest of a child to access Wikipedia, even though it has a lot of harmful content on it. But the difference between Wikipedia and other things that they might access is it doesn't chase them for the next 6 months saying, hey, how about a bit more? And that's the distinction that something like that can make, that you can actually make a reasonable. And this is, I guess, my final point, is this is designed to be reasonable. It doesn't have the sort of the harsh certainties of some law that can actually have unintended consequences. Kids are online, they need to be online. It needs to be designed in a way that gives them some privacy and safety.
Thank you very much. So are there, when we talk about it's focused on the risk and evaluating the risk, are there any definitions of what would constitute like a high level of risk or medium level of risk, or is that kind of a self-assessment left?
It is, but I think that there are. I mean, the ICO did quite a good job of creating a narrative around risk. I mean, they published. They were very good, actually, because it was the first place in the world that it had been done. There was a number of sandbox and a lot of stakeholder engagement. And in fact, I did loads of workshops on behalf of the ICO talking about risk. And in the room was everyone you can imagine, theoretically all on the different sides, but we were all in the room together. And I think what they do is ultimately the risk is in the eye of the enforcer. Ultimately, they can say, you did or didn't meet, and we think that case law will ultimately, settle any disputed elements. But the ICO gave very good guidance about risk, and did set out what seemed to be very acceptable to industry guidance that pointed at that. Nicole.
Yeah, I would just say there was a lot of discussion in California about the level of risk. There were amendments that went in early, and it said more than a de minimis risk of harm. And that is clearly a very low standard, and industry had a big problem with that. And so, we went back and forth. And I think there was universal agreement that something like a substantial risk of harm is absolutely unacceptable and inappropriate. Right? If you know that your product has a substantial risk of harming children, you probably should not be rolling it out. And so what was settled on in California was a risk of material detriment, which, clearly not everyone was happy with that, but that was the middle ground we settled on. Personally, if I think there's a risk of material detriment, it's probably still a little bit too high. But trying to establish that standard was challenging, but material and detriment are things that clearly our courts in the United States are going to know how to analyze and look at.
And because there's no private right of action, but there is enforcement, it also takes some of the toxicity out of the absolute answer to that question. And in the UK, the ICO, which has the enforcement powers, which are quite substantial, really up to 10% of global turnover, published that they would be not seeking the advice of, but they would take as a measure official government advice from people, for example, the chief medical officer, the Department of Education, the doctors, etc. So they said, look, if you want to know how we're thinking, this is what we're thinking. And that was that's been actually quite successful, let's say. It raised the bar but it didn't raise it to, but nobody's worried about it. Do you see what I mean? And the whole thing sort of works like that. It's almost like its own nudge theory.
Thank you very much. Are there any other questions for Nicole or for the Baroness? I do have a question in regards to if we wanted to work with you as we move forward with our legislation. What is that process and how would we engage?
Speaking for myself, I would be utterly delighted, and so long as everything's on a bipartisan or non-partisan basis, I'm in. And Nicole is the contact person and would do the running, as it were. But I am utterly committed and utterly available if this is something you choose to do.
Great.
Yes,
Thank you
and
so much.
I would say that I have taken the California bill and scrubbed it of any references to California, and made it into model legislation. So we have something drafted that I'd be willing to share to take a look at, because the goal really is a universal standard.
That would be fantastic if you would mind sharing that. And I do see we have Paul and then David, and then we'll have to get on to our next presenters. So, but thank you so much, Baroness, for taking the time, and thank you, Nicole, for your time and for setting up and getting the Baroness to address us. So, Paul?
Yeah, thank you for a great presentation. I just had a very quick question. Just what was just about the private right of action and the decision not to have it? What was the number one factor, would you say, on the decision not to include the private right of action?
Well, I wish that I could say, that we take credit for all decisions that were made. But the fact is, throughout the committee process, there are certain things that you have to do. And in California right now, the Senate Judiciary Committee doesn't let out a lot of legislation with private rights of action. So I mean, that was one of the factors. But like I said earlier, because we are talking about design and not harm that's actually been experienced by children, having it enforced by a regulator seemed appropriate. Sorry, Baroness, go ahead.
No, I mean, just to back that up, it was really, I was very keen on that decision because it is the systemic nature of the code that is its power. And we didn't want it to be constantly about an individual failure. So it's much better if you have a regulator or if you have an AG to uphold the values of the law. You get quicker to the good place, and less defensive action from the tech companies and more proactive action, which is very different from self-regulation.
Okay, no, thank you very much. Yes, I totally agree. I just was interested in the factors there. So thank you.
Thank you, Paul. Thank you, Cole. David.
Just quick question, Nicole. You mentioned having a scrubbed version of the bill. Have you guys produced or could you produce, not to try to make you do work, but could you produce a version of the bill that tracks the Connecticut, Colorado model of state privacy law? Obviously, California is much different. We've linked in Connecticut, the bill, the consumer data, the Connecticut Data Privacy Act follows the Washington Privacy Act model, so it has a different terminology and thresholds. So I'm interested in whether you've created like a version of your bill that tracks that.
So I think we easily could. It's not, quite as simple as copying and pasting. We'd have to look to each of the definitions. I did look at the Connecticut bill. The fact that a child is defined as someone under 13, I think would be problematic since we're trying to raise the standard. So, I mean, yeah, the answer is yes. It's easy enough to incorporate definitions from a particular state and just strike that part out of the model legislation, but we would need to go through and carefully look at making sure that the 15 standards are maintained when we incorporate those definitions and work it into a legal landscape. But yes, that is what I was hired to do. So yes.
Yeah, David, I was about to offer her up anyway, but but thank goodness she offered herself up. The one thing I will say, which actually we made a decision today, is that we are also going to, because we're seeing it go around the world, we're also going to offer to have the narrative explanations that we're seeing, and to take the best of that. So we'll have the model legislation, but we'll also have a model narrative explanation of those. Each one of those will have to be carefully, tuned. But I think that it has become clear that having this conversation in narrative would be really useful for people as well, as a starting block. And I expect to have that by mid-January. So, and available to, obviously, to Nicole, and obviously, therefore, to you.
Thank you so much.
Great. Thank you so much for having me at your meeting. And I am now going to go and finish my day.
Thank you again for your time.
I'm delighted with the indication that you may be interested in going this route.
Thank you so much, and we will be in touch. Bye. So, is Sarah on? Sarah Holland?
Yes.
Hello,
Hi, Sarah. How are you?
I am good. How are you?
Good, thank you. And so, are you all set to go now? Just to talk a little bit about what Google's been doing, and I think one of the interesting things you had spoken about at the TechNet conference was also just making sure we're looking at children's rights, right, as well when we're looking at it. So, but if you could just, if you're all set, want to take it away, the floor is yours.
Great, thank you. And thank you so much for having me and for having Google. It's nice to see you again after that conference. And it was nice I was able to join for the last bit of the presentation from Five Rights. And just, I want to start with acknowledging that they have been such great champions, especially through the Age Appropriate Design Code, of really talking about this idea of focusing the legislation that would protect children on children themselves, right? So I'll speak a little bit about that, about our perspective, and how we think that that can be defined and why that's important to define across states, and then talk a little bit about what we've done lately. Google's got a long history in terms of like building protections, but we've definitely taken it up a notch lately. So I'll talk about that, and then maybe a little bit of the views that we are seeing from an organization that's working to comply with a lot of these regulations around the world. And so we can spend a little bit of time talking about that if that is helpful. And then people can interrupt with questions. I don't think I'll take the whole rest of the time, so I'll breeze through, but if I need to speed up or pause any of these, let me know. It might be helpful just to start with the level set of like kind of Google's approach to building these products, thinking about the design, which I think Nicole was just talking about. Like, this is really about systemic design as opposed to addressing harms on the back end. And so we really have basically like a three-pronged approach. The first one is to really think about building age-appropriate products that align with kids and teens' developmental stages and needs. And the keywords there are age-appropriate and developmental stages. We can talk a little bit about that. The second is that we give a lot of tools to families so that they have the flexibility to manage their unique relationships with technology. And the third part is implementing enforceable policies, protections, and programs to help keep every kid and teen safer online. And we think about this in terms of privacy, in terms of safety, anti-exploitation efforts, security, rights to access, freedom of information, freedom of expression, and then overall well-being. And so let me kind of put that into more practical terms of what that means, because those are three like nice high-level statements. What this means is that we don't take a one-size-fits-all approach. So Google is a company that operates around the world and has a lot of users, but we really want to take an approach that is like really thinking about our users and what's best for them. And so when it comes to kids and teens, what we want to look at is that what works for an somebody who's under the age of 12, for example, is not necessarily something that we want to copy and paste to a user that may be 13 to 17. So thinking about this is treating kids as kids, teens as teens, and then we can get into a little bit of this later, treating adults like adults, because the protections that we put in place for kids and teens, we also want to think about what that means in terms of the change of products and services and what that might mean for the general population. And then it also want to make sure that we're highlighting that we want flexibility so that people can like develop and set their settings and tools in a way that they want to, but that there is a baseline protections even if they don't take advantage of those tools we offer. So it's ensuring that what works for my family may not work for yours, or the other way around, and thinking holistically about all the different kinds of families that may come to use our products and services. And so we have a lot in this space, but let me just focus on a few. And these have been some of the recent changes that we've made. And then I can talk about Family Link, which is probably a bit of the jewel of our crown when we're talking about what we do for families. So the first, which may be on the top of a lot of people's minds when it comes to children, is advertising. And so we've always had policies about advertising in kids, but recently we took the step to block ad targeting based on age, gender, or interest for people that we know to be under the age of 18. With search, we have a filter called Safe Search, and we have turned that, again, for users that we know to be under 18, we've turned that on by default. And then we've also given an option in image search so that people under the age of 18 can request that their images be removed from image search. On YouTube, we changed the default upload setting to the most private option available for teens ages 13 to 17. YouTube Main, of course, is only available for children over the age of 13. And then with well-being, we've expanded a lot of the well-being tools we've offered. So this can be like take a break, bedtime reminders, things like that. Some kind of nudges for people to think about their relationship with technology. And we're going to continue to roll out changes. This is obviously not a one and done for Google. This is something we're continuing to look at. And I haven't even talked about a lot of the really great programs we have like Be Internet Awesome, where we're really thinking about digital literacy and building those skills in that can last a lifetime. So with Family Link, it is it's really a parental tool that helps keep parents in the loop, I think is the way that we want to frame that, and really help parents set digital ground rules. So we see a lot of usage for parents setting this up for children under the age of 13. So it's a great way to kind of keep an eye on online activity, guide your kids towards great content. You can set screen time limits with it. You can manage apps that children use. You can block in-app purchases, for example. You can set to approve certain apps for download. You can set content filters on Google Play, set a bedtime for the device, share location, manage privacy settings. So it really is like a host of tools across the Google suite of products so that families can really make some decisions. And then we also give some resources to help kickstart what we think are productive conversations about how best to use and balance technology. And just a couple of months ago in October, we released a couple of new features. One is what we call today only screen time settings. So this is kind of nice, as if there may be a special exception where you want to make a change to the general policies and the settings that you've set up. Say you're on a long family road trip, you can set that where a setting can apply only for the day. And then we also updated the location tab, where parents can see all their children on the same map with the device locations. That's particularly helpful if you have a lot of kids you're kind of trying to keep track of, making sure that that's really nice and easy. And then you can also turn on specific notifications so that you can be alerted if a child arrives or leaves at a specific destination, say school, soccer practice, home, things like that. And while Family Link is where we've really kind of centralized our parental controls in one place, there are a bunch of others that we have elsewhere. So for example, there's lighter weight profiles and YouTube Kids with in-app parental controls. There's things for like shared devices like Google Home, if you have one of those, where we have additional device level controls for parents who want to set that content. And then the last part of this is the policy and transparency resources. So this is like our privacy guides, our policies, where parents and kids of all ages really have access to clear, accessible information about our privacy policies so that they can make meaningful choices. So it's not enough just to have choices, right? We want those choices to be meaningful. And so the transparency and the policies that we have are a key part of that, ensuring that people can control their data. So that's a bit about what Google is doing in this space. Like I said, kind of stay tuned, because we like to cook up more things that we can do that better fit the experience that people want to have when they choose to use Google products and services. I think we can talk a little bit, if that's okay, about maybe some of the stuff that we're seeing in privacy and safety legislation, some of our views, what we're seeing in terms of what we've done in compliance with regulations that are on the books, and what we're seeing with kind of like what's cooking elsewhere. So one of the key things that I think is important for Google, we've talked about like treat kids as kids, teens as teens, adults as adults. And I think that a great way to do that is to really think about age appropriate protections, so that you're not treating all children the same. They're very different, right? For younger, maybe someone under the age of 12 versus someone like 16 or 17. And so we do want a nice systemic approach, but with that room for nuance, right? Where you can really tailor those protections. And I think the best interest framing of the child is a really great way to kind of do that. And from our perspective, we think it's really important to put some principles around what that best interest of the child means, because in the example of the age-appropriate design codes, that's really kind of a linchpin of the regulation. And as we see with the United States, certainly setting the rest of the world aside for a second, what we're seeing in the United States is there may be a very different view from the regulators, from the citizens of a state, of what is in the best interest of the child, right? So what works in Connecticut may be different than what works in Texas. And this can be true for how you design a product, the settings that you put as the default, but also content decisions. And from our perspective, from the Google perspective, where we're operating across state lines, that can be really, really helpful to have some of those high-level principles that can provide some commonality of what we actually mean by that standard. And there are global standards that we can pull from. And I think some of the things that we would like to see on that are really thinking about these truly what is in the best interest of the child, but thinking about these different rights, these values, right? These things that we want to protect that can really ensure that a child's well-being is being looked after. So from our perspective, that's privacy, of course, safety, security, but also things like freedom of information, right? Access to information, freedom of expression, the idea that you can access the world around you with appropriate controls, right? But that is not something that we are sacrificing in the name of these other interests and values and rights like privacy and security and safety. So we really want this nice holistic view of what is in the best interest of a child, so that we can kind of balance that as we are considering how we're designing and developing new products and services and features, and that really providing the best experience for our users and really looking after the best interest of the child. So something, again, to consider as you're thinking about this in Connecticut, but also what this might mean for children elsewhere. It can also help really acknowledge the First Amendment in the United States and ensure that we have consistent policy enforcement when it comes to things like content decisions. The second thing, in addition to the age-appropriate protections, is really taking a risk-based proportional approach. This can be particularly helpful in certain provisions. So, for example, if a bill would require age inference, but really thinking about, okay, what are the outcomes? Let's start with the defined outcomes of what we want to achieve, and then how we're going to get there. So making sure that the approach is really thinking about that first, mitigating the risk, but also taking a proportional approach. So for example, an age inference, if you require a very granular requirement that you're trying to identify the age of a user where that might be unknown, and you need that to be very specific. So you're wanting to identify if that child is 16 versus an age band, that may require more data processing, may require more data collection. And so we want to think about, is that actually the outcome that you all may want to achieve from that law? But just thinking about where these dials can be turned, but making sure that we're thinking about that and that the protections are really tailored to the level of risk. We also want to talk about complexity and trade-offs. So I got to this a little bit with the best interest of the child. We want to make sure that we are achieving all these like goals, these rights, these freedoms, these liberties and values and protect. And I think that it's really important to kind of like think about that as we're considering what these obligations may mean. We also want to kind of put a pin here to highlight that the methods and approaches that we may take to reach compliance that other companies may be taking are flexible, and that we can ensure that we're being inclusive, and that we are really focusing on these risk mitigations, these tailored age-appropriate experiences, these protections, but also allowing a lot of the great benefits that technology does have to offer in terms of education, connections, play, preparing for a 21st century workforce. And so when we can kind of consider these complexity and trade-offs, acknowledging them, right, then that really helps ensure that we're getting to the stated outcome that we want. The example I think about, and I apologize if this is redundant or far afield, but when I worked on legislation in the US Senate, we were working on an accessibility bill. And some of the folks that we were talking to wanted to mandate that there would be a button on the number 5 of a phone. I think some of you may remember back, like when you have like a landline or a non-touchscreen phone, there usually is like a little dot, and that can help kind of orient a hand for people who are blind or low vision so that they know kind of where they are in the keypad and can kind of use the keypad. So super helpful feature. However, the further we got kind of in the thinking was, once you realize that if you required and mandated the button on the 5, then that may be a hindrance to the development of a touchscreen phone, for example. And so what we didn't want necessarily was the button on the 5. We wanted the functional equivalent of the button on the 5. And it could be the button on the 5, it could be something else. And we wanted to encourage companies to leapfrog beyond just the button on the 5 and really think about, can you actually provide an even better experience for people who need accessibility assistance? And so that was a really great way. I think, I'm obviously biased because I worked on it, but it was a great way to think about achieving the outcome, acknowledging the complexity of trade-offs, but really stating what we wanted to achieve, creating that outcome, and then providing a lot of flexibility and encouraging, incentivizing that innovation to meet that goal. And so that's something that we think can be really important when it comes to kids' privacy and legislation, is you always want the best brains thinking about how to make this better, and not just hitting some check the box exercises. We also want to enable responsible innovation. So that's a related point, right? Really making sure that you're thinking about products and services that are benefiting children, benefiting teens, benefiting families, and thinking about all types of children, all types of teens, and all types of families. It is not related to this conversation. It was about a federal bill, that Kids Online Safety Act, that was being considered. And I saw that a bunch of groups had written a letter to the Senate, kind of raising some of the issues around that and certain populations that they thought may have been impacted by that bill. And I think that's just like a great reminder that there are a lot of different children and teens that may be in different situations, that may not be in safe situations, maybe fundamentally at a different position than their families, for example. And we want those protections to apply to them. We want their best interest to be considered, as well as the best interest of children who are in less vulnerable situations. And so really thinking about, again, that flexibility, but that responsible innovation, so that we're challenged to kind of continuing to do and build great tools like Family Link, and things like that, and thinking about and setting aside things that may require pre-clearance, so that ensure we do have that runway, that we know exactly what the outcome is, that the policy goals that we need to achieve, and that we are then working to build that with accountability, of course. And then the last thing, because it wouldn't be, I think, a presentation from a tech company if they didn't talk about regulatory interoperability. That can just be really important. Like I said, with the best interest of the child, really thinking about what that might mean across state borders, even if it is a state bill. But for us, we really need to think about that to ensure that we are kind of meeting our obligations, providing the best experience we possibly can. And that can be challenging across state borders. Within the United States, but also as we think about laws outside the books. So it's great to think about like what's been working really well in the United Kingdom, right? And how that can be applied to the US, but also thinking about the unique kind of legal and cultural traditions that the US might have that may need to be considered as part of kind of building that legislation here. But thinking about regulatory interoperability, we think will produce a really great outcome, ensuring that we have these strong protections for children, but they're also able to kind of get the best of technology. So I'll stop there, can talk a lot about age assurance or any of these other issues. Love talking about this, but I'll pause there just to see if anybody has any questions. And then obviously, just in case I went over time.
Sarah, thank you very much. Are there any questions? Questions? And I think one, it is an interesting, or not interesting, it's a very important point you raised, right? That we need to think about the outcome, right? And more regulating outputs than inputs. And, how do you build in that flexibility, especially in Connecticut where we don't have rulemaking, right? So we need to put it in the legislation, and we know that's a time-consuming process. So how do we not hamper innovation, but achieve a common goal of protecting our children? So it is we're protecting our, not just children, but protecting our residents' privacy. So, are there? I don't see any questions. I want to thank you very much for your presentation, and then thank Ron as well from Google, and then just see if you would be available as we do move towards coming up with some legislation. If we do put out legislation, just hopefully you would be open to discussing this with us further as we move on.
Absolutely. Happy to help whenever you need us. So sign Ron, Angela, and I up, and we'll be happy to chat.
Thank you so much, Sarah. And so with that, Michelle, are you able to speak?
Yep, I'm here. And I can try to keep it brief too. I know we're running up on time here, but my comments are going to be brief anyway. So I'm ready. Okay. Well, first, thank you very much for the opportunity to speak today on behalf of the Attorney General's office. I should say up front, and I know everyone on the meeting today knows this, but protecting kids and teens' privacy is a real priority for our office. It's an area that the Attorney General feels very strongly about. And when we were weighing in support of Connecticut's privacy law, we did flag that this was one area that warranted careful consideration, whether the law went far enough to protect tweens and teens. And the presentations today have been very helpful. Thank you very much. I'm sure it will spur a lot of discussion in this area, and we will really look forward to that. That all said, we also flagged a language issue with Connecticut's law that we wanted to address today. It has to do with the liability standard for teens data. And I think it was an inadvertent issue, but it is something that would really dilute the protections afforded to teens. And so just to take a quick step back, what the law currently provides is that controllers shall not process a consumer's personal data for targeted advertising or sell personal data without consent where a controller has actual knowledge and willfully disregards that the consumer is at least 13 but younger than 16. The word "and" is what is significant here. So the language had previously included the word "or," so that the standard hinged on actual knowledge or a willful disregard that a controller is selling teens data or processing that data for targeted ads. And so that's the issue. This "and" structure, we are concerned that it sets a too high standard and frankly, a confusing standard. It's also a departure. So this "and" standard does not appear in other state privacy laws. You've also already heard today that it's not in existing federal privacy laws or current federal proposals. And then beyond that, I'm not even aware of laws in other areas that require both actual knowledge and willful disregard for liability. So that's the issue that we're looking to address. All in all, we fully support looking at how we can do even more to protect kids and teens' privacy, but at the very least, looking at the language in Connecticut's law as it exists, we think it's critical to address this issue that was caused, I think, through a drafting error. So thank you very much for letting us weigh in. I said I'd be brief, so I'd be brief, but if anyone has any questions, happy to address those.
Great. Michelle, thank you very much. So first, let me, as part of my apology tour, that I did review emails, and that was indeed my fault. And it was a drafting. We did have agreement around the or language, and it came from the LCO had asked to change it, and then the goal was to match California, but by changing it, we actually do not match California. So unless someone can speak otherwise, looking over my emails, we had agreement on the or language. And so that is a change then, a correction, I wouldn't say a change, a correction that needs to be made. I do have a question for you, because it's come up before in speaking with others, at different conferences and speaking with other people around privacy about why we do not have rulemaking for the Attorney General in Connecticut. And so I haven't been able to answer that. I know you do not have the authority. I don't know if you can shed more light on why you do not have that authority, or if you could just clarify that indeed you just do not have the authority to do rulemaking.
Yes, absolutely. So, right, Connecticut is different than states like Colorado and California because our office does not have rulemaking authority. This has to do with Connecticut's Administrative Procedures Act, the APA. Under the APA, rulemaking authority rests with our client agencies. So our office reviews regulations that our client agencies draft. We do that function, but the rulemaking happens at the agency level in Connecticut. So I guess in other words, the APA breaks out the roles in Connecticut between our client agencies and our office, and the client agencies draft and our office reviews.
Great, thank you very much. So I was partially correct when I was making up an explanation for it then, but I like to give an actual answer from someone who really knows what they're talking about. Just making something up. So thank you. Are there any other questions for Michelle? Okay, well, thank you very much. And so just, I guess, to go a little over the process for everyone, we do have another meeting scheduled for next week. We have a representative from the Hospital Association to speak on the data co-location issue. We have Senator Rodriguez from Colorado is going to address us on the nonprofit issue, why they chose not to include nonprofits. So if we look at it, we should expand these provisions further. And then we also do have, I believe, Assemblyman Wicks from California to speak a little more on the California Age Appropriate Design Code, as well as another organization to speak of potential issues that have arisen with the Age Appropriate Design Code. And then I will be reaching back out to one of the speakers who was unable to make the meeting when we spoke on AI. And then from there, we start our legislative session on January 4th. The plan was to have a meeting on January 3rd, so in between the 14th and the 3rd. I don't think we won't have anything drafted as far as legislation to look at, but I think what we'll do is we will circle back and I will send out some emails as we gather some of the ideas of bullet points of things that we will want to potentially include in legislation. And then once that concept is raised, then it'll go to through the public hearing process. But thank you, everyone, for your flexibility. Again, I apologize for switching the meeting from last week to this week, and thank you for your help. I'm not sure if there are any other questions or if any of the co-chairs have anything else that they would like to say, but otherwise, just again, thank you for all of your time and assistance in this process. Okay, not hearing, seeing no other questions, thank you very much, and we'll see you all next week. And we will circulate the presentations and the contact information. Sam will get that out to everyone.